your camera off unless you're presenting. Thanks, everyone. And I'll pull up your PowerPoint now.
Okay, great. Well, thank you.
I started recording. Sorry.
Thank you, Jackie.
Thank you so much, Amy. I just want to give another shout out to Erica as well for making this happen, connecting us with you. And on behalf of the entire team here who are also going to be speaking to you, I want to say thank you for having us. This is a wonderful opportunity for us to be able to get the word out about the mental health treatment court that we have here in Milwaukee County. For those who don't know me, I'm Judge Cynthia Davis. I am a circuit court judge in Milwaukee County. I've been a judge since 2016. And for about 3.5 years, I had been presiding over all of the various treatment courts in Milwaukee County, the ones that are housed downtown. And it's been just a great experience having presided over those treatment courts. I had presided over the mental health treatment court a little bit longer, for about 4 years. And then this past August, I rotated out of that position, and Judge Carolina Stark is now presiding over the treatment courts. But as Amy mentioned, we have a number of other team members who are here who will also be presenting today. And again, the purpose of the presentation today is, one, to get the word out about our program, but then also we have left a considerable amount of time to just leave it open for conversation with all of you. We are looking for ways to increase our collaboration and improve our communication with our system partners, which are all of you who are here today. And so that is really the overarching theme of the presentation. And Amy, I don't see the PowerPoint, but is that something that I'm not going to see?
Oh, nope, you're going to see it. Just let me know when you're ready for it.
Oh, okay. All right. We're ready to
You're all set?
We're all set for the PowerPoint. Thank you.
Okay.
And we can just go to slide 2. So before we get into the nuts and bolts of the mental health treatment court, I'm going to give a brief overview of just what treatment courts are in general. And I do apologize if this is somewhat review for a number of you, but I know there's just a wide variety of experiences here, wide variety of knowledge of the treatment courts. So I wanted to give that basic overview first, and then we'll get into the nuts and bolts of our particular mental health treatment court that we have here in Milwaukee County. The definition of a treatment court is a problem-solving court that takes an alternative approach to the traditional adversarial court process by implementing a coordinated response to participants who, it depends on the circumstances, who are either dependent on alcohol and other drugs or those living with a mental illness. So in the context of a criminal treatment court, the gist of what a treatment court is that instead of a person going through the traditional court process and getting sentenced to prison, jail, or probation, the participants enter into the treatment court program that allows the defendant, whom we call participants, to stay in the community as long as they are complying with the treatment court program, which the program is oftentimes, and we hear this directly from participants themselves, that the treatment court program is more rigorous for the most part than probation. And some participants have said to us too that the treatment court program is much harder than if they had just simply been sentenced to jail or prison. The key though is treatment courts are a voluntary program. So no one is forced into it. In fact, the participants have to be deemed eligible, which we'll get into that later. But once they are deemed eligible and they agree to enter into the program, they have to sign a written agreement by which they are agreeing to the terms and conditions. So what's the benefit then to participants to engage in the treatment court program? In the context of a treatment court for a criminal docket, and I'll get to examples of treatment courts that happen outside of the criminal docket. But for those types of treatment courts, the carrot is that at the end, if the participant is successful in completing the program conditions, they graduate. And upon graduation, sometimes the result is that their case is dismissed. Felony charges can get dismissed. Sometimes the charges get reduced, for example, from a felony to a misdemeanor, and they get sentenced to time served. Sometimes the carrot is that they were sentenced to probation as part of the treatment court program, but they are able to terminate probation early. And then, of course, altogether, the benefit is participants are avoiding having to be incarcerated. And then in the family context, where, for example, in Milwaukee County, we have a family drug treatment court, that is something that's occurring in the civil realm, but the carrot is reunification with your children. So in Milwaukee County, we have various treatment courts, 3 of which are housed downtown and have a criminal docket. That's the Adult Drug Treatment Court. And that focuses on high-risk, high-need individuals who have committed criminal offenses and they have significant substance use needs. We also have a Veterans Treatment Court. And that is, as you would guess, is for veterans. And it's a hybrid type of treatment court, meaning it addresses veterans who have either a substance use issue, a mental health issue, or both. And then the other treatment court, which deals with a criminal docket, is the mental health treatment court that we are going to discuss in more detail today. But again, that's a specialty court as well. It focuses on the treatment instead of incarcerations. And we are targeting in that court people who are suffering from either a serious mental illness or a severe and persistent mental illness. We are also looking, and this might be discussed in more detail later, but we're looking for a causation, some link between that mental illness and the criminal activity that brings them into the system. It's typically then a 12 to 24 month program. We're currently reworking the program to create phases of the program. And again, the goal is to connect these individuals, our participants, to appropriate services. So basically with all of you. And it was started as a pilot program back in February of 2014 by Judge Kremers and then by attorneys Paige Styler and Jeff Altenberg, who both of them are here and will be speaking to you shortly. So the other couple treatment courts that do not operate with a criminal docket, these are out at Children's Court, are the Family Drug Treatment Court, and that is a treatment court that focuses on participants, so parents who have the substance use issues and whose their children are subject to a CHIPS order, a child in need of protection or services, and the focus is on reunification of those children to the parents. There's a Healthy Infant Treatment Court that's housed in the Children's Court, and that is targeting infants who have been removed from their home pursuant to the CHIPS order. And that program specifically works with the infant's appointed caregiver to connect that infant to services that are going to help foster healthy relationships and promote healthy development. So just by way of a brief history of treatment courts in general, Dade County in Miami, Florida had the first drug court, and that it was established in 1989. Wisconsin had its first treatment court in Dane County that established an adult drug treatment court in 1996. And currently, there are approximately 100 treatment courts established in Wisconsin. And nationwide, there are about over 4,000 treatment courts, and then at least 13 other countries have also adopted the treatment court model. So while the different types of treatment courts vary, there are some general components among all of them. And those include one, that the treatment court takes a non-adversarial approach. And so you're going to hear from the prosecution, Attorney Altenberg, and the defense, Attorney Styler. And I'm sure they'll be the first to admit that they don't always agree on things, but the benefit of being in a treatment court is that for the most part, the prosecution and the defense, along with the rest of the team, are working together toward a common goal. Other components of a treatment court are that we're trying to identify and place eligible participants into the program as early as possible. So that's where our collaboration and communication with our system partners can help us a lot, so that, you know, any one of you could make a referral. If you have someone whom you think would be appropriate for any of our treatment courts, we would encourage you to reach out and let us know, because the goal is to try to identify those participants as early into that process, you know, right after someone's charged with a crime or even before that, we're identifying them. Again, we're connecting participants with a wide variety of services. In most treatment courts, there's drug testing and alcohol testing to monitor abstinence. One of the key components that I particularly like is ongoing judicial interaction. So there's evidence, there's been much research to support that the judge and the judge's role on a team actually does make a difference. So, you know, that makes the judges feel good about themselves. But there's great benefit then to having participants appear in court, sometimes on a weekly basis, it depends on how they're doing, in front of the judge, and really establishing a great personal relationship with the judge. And that's been one of the highlights of my career as a judge, is having that interaction with the participants. A couple other key features are that we are always trying to implement measures to evaluate our program. We want to make sure that what we're doing is effective, and we are always, as team members, engaging in continuing education, because that's a really key piece for us, because we are engaging in what has been termed therapeutic jurisprudence. And, you know, for most of us, well, I'd say for the legal representatives on the team, we are not specifically trained, right, as mental health professionals, as doctors, etc. And so when we're engaging in sort of therapy, we have to make sure that we are doing it correctly, because the evidence shows that when you follow the evidence-based practices, you can do great good. But if you're not doing that correctly, you can also do great harm, and you can do more harm than if the person had just stayed in the traditional court process and had not entered into any treatment court. So one of the things that is discussed when we're trying to foster support for these treatment courts is, what are the benefits to the community at large? Why should we expend taxpayer dollars, for example, to support these treatment courts? And there's now been enough evidence and research to find that treatment courts have been shown to increase public safety due to lower rates of recidivism. And there's also been shown to be cost savings to taxpayers due to those lower recidivism rates, and then due to the decreased use of incarceration. And we've been tracking those numbers now in drug treatment court and veterans treatment court. So we've really been able to see the overall benefits. So with that, I'm going to turn it over shortly then to our attorneys who are on the team. But I just wanted to end my portion on a really positive note, and that is just to highlight just how great these treatment courts are. And maybe this is me preaching to the choir, maybe not, but as a judge, as I noted earlier, I was able to be part of a process where I felt like I was able to really affect great change by having that personal relationship with each of the participants. I felt like as a judge, I was able to benefit from the expertise of all of the members on the team. So I'm not making a decision. The judge makes the ultimate decision as to what happens. For example, if there's sanctions imposed, etc., if there's things that go wrong. But ultimately, I am relying on the expertise of all of you, all of the team members, the system partners whom we're collaborating with, to make a very good, informed decision. And treatment courts, in my mind, it's taking an approach that is veering away from just slapping a Band-Aid on the problem and hoping it goes away. And it's taking a holistic, individualized, integrated approach to healing. It's trying to get to the root cause of issues. And it's a way too that we as a criminal justice system, as a legal system, can interact with participants who, may have been marginalized, that we're able to treat them with dignity and respect. And that's been one of the most rewarding experiences, is to be able to have share that experience with the participants. And I know Attorney Styler and Attorney Altenberg will share some more of the success stories that we've had, but I did want to end on that note. And with that, again, I want to thank all of you for being here today and learning more about the Mental Health Treatment Court. I'm going to turn it over then to Attorneys Styler and Altenberg.
Hello, everyone. Jeff, are you there?
I am here.
Okay.
Good afternoon.
Good afternoon, everyone. So Jeff and I will just talk to you a little bit about what it's like from our perspective as not only, my side as a defense lawyer, his side as a prosecutor, but also how we work collaboratively in these courts together, because frankly, these cases and the clients don't get the help they need without that collaboration. If we don't have it, it just plainly just doesn't work. So I think I'll just start first just talking about referral process from the defense side, and then I'll have Jeff talk about it from the state side. Basically, it's similar to what the judge just talked about with respect to all of you in terms of if you've got clients who you think might be a good fit. So similarly, that happens from the defense side. Obviously, we deal with a tremendous amount of individuals with major mental health issues. I would say in my career, when I first started, it seemed to be a group of us who specialized in clients who had severe and persistent mental illness that were in the system. And today, I don't have any group that centers just on that, because every single person in my office on their caseload have clients with severe and persistent mental health issues. So we've certainly seen in the 30 years I've done this, a huge uptick in the number of individuals coming into the criminal justice system with major mental health issues. So we definitely have kind of enough individuals that might benefit from being placed in a mental health court. But I guess the question is, how do you make that determination? One of the best things that we have right now is we have a coordinator. And so the added benefit that we haven't had in the past is we have someone who will be looking, when you make the referral, Courtney Brooks, who will be speaking to you later, is going to have the ability to take a look and gather other evidence to see if the person is the right fit. But generally, from the defense perspective, we're looking for people, as the judge said, that have a major mental health issue. And for individuals who are, first of all, not contesting their charges. This is not a court that's to be used for, if the client just indicated they didn't do the case, then you just do the traditional role of the criminal justice system. But there's a lot of people who are pretty ill, and when they were ill, they committed crimes. And so this is an avenue for the client to get some help. I think it's important to note that a client that is currently incompetent, or if a lawyer feels like their client is incompetent, then it is not the time to refer them for mental health court. We only look at people who are competent. That does not mean that if a client who's already been admitted into mental health court becomes competent, and that has happened numerous times, or they become incompetent, I should say, then we just take a break. They go to the hospital or whatever has to happen to get them well, and then they come right back into the court. But one mistake people make is they will have a client who is been found incompetent and they're already making the referral. We won't kind of do anything with the case because legally that case is suspended. We can't do a thing with it until the individual has been opined that they're, and a judge has found that they have been restored to competency. So from the defense side, we tend to refer everyone and anyone who fits that. And what I mean by that is usually the people with major mental health issues have some violence in their past. So right now, in the infancy of this court, I guess we err on making the referral. And if the state turns around and says because of someone's background, criminal background, or because of victims or so forth, can't come in, then they can't. And that's just a decision made on the DA side. But right now, we err on referring most people if we think they can benefit from the services that come from mental health court. So aside from basically filling out the paperwork, gathering as much information as we know about their background, what medications they are or are not on, that's kind of how we do it. I would say in terms of who I wouldn't refer is if a client doesn't need, I'm really looking for like high risk, high need, or at least moderate risk clients. If someone basically, got off their meds, or they had some other criminogenic need that got in the way of things and they've kind of self-corrected and they have a limited criminal record, there are other diversion type programs that we have, but it probably would not be the most appropriate to put them in this this program, because this is really for your high risk, high needs, or moderate risk, high needs individual. The referral forms, I just saw that come up on the chat. I'm sure that Courtney can send them out to everyone so that you have them at the end of this, but she's got a referral form and some releases that would need to be signed. So I'm going to let Jeff go at this point, talk about referrals from the perspective of the state.
So what you've heard from both Judge Davis and Attorney Styler is an excellent overview of our court. The role of the state, as Paige mentioned, it is certainly to be collaborative. We certainly understand that unless we can work together to address individuals that have severe and persistent mental health issues in a collaborative way, the adversarial process is not really conducive to allowing people to get the help that they need, and frankly, the positive reinforcement that they need from the judge, the prosecutor, and the defense attorney. So Paige is right. We do look at a lot of different cases because we do have the ability to do either enhanced probation or, and more recently, we've tried to do some deferred prosecution agreements where individuals plead guilty to the offense that they're charged with. The court accepts that plea, but does not enter judgment of conviction, and then has them participate in the court and the program for 9 to 18 months. And if they successfully complete, their case can be either dismissed or reduced. So that gives us a fair amount of latitude in the types of cases that we can look at. We don't look at real violent offenses, homicide or attempt homicide or felony level sexual assault. But At the same time, we look at cases that we probably wouldn't look at in some of our other early intervention programs. We've had reckless injury, reckless endangering safety, stabbings, arson, both misdemeanor and felony level arson. We've had bank robberies. We've had bomb threats. So, and that's just to give you an idea that we do look at a variety of offenses, and we look at their criminal history. But equally important is we consult with the victims, and that's really the state's role, is to make sure that the victim understands what mental health treatment court is all about, how it would work, how they can participate, and make sure that they are essentially consenting. There'll be cases where we'll contemplate mental health treatment court, and based on the input of the victim, we just decide that it's not appropriate. At the same time, there are many victims that once you explain the process and what you're trying to do, and frankly share with them what the individual will be required to do by the court, that they get on board, that they agree that that is an appropriate way to handle the case. So that's really my focus as representative of the state. And then my other focus is to be as supportive as I can as a member of the team of an individual's treatment and recovery. And also, when necessary, to hold them accountable along with the judge and the rest of the team when there are transgressions or violations. But we really do try to focus on the positive. We try to, every time we have an interaction, which is typically in court, at least on my side, I try to emphasize all the good work that the individual is doing, but also impress upon them that when we are asking them to do things, it really is because that's what the treatment provider indicates should happen. I'm not there to be a naysayer or negative at the same time. We are there to make sure that what is required under the agreement or the sentence is being followed, and the entire team shares in that process kind of collectively. I would echo what Paige said. Having a coordinator, having Brittany or Courtney on board now is huge for us. It really does allow us to have a structured program that is a little more transparent. We're working on policies and procedures. We're working on forms. We have a clearinghouse that is Courtney that will answer questions and steer people in the right direction. And it hopefully allows us to move off of what has been almost now a 10-year pilot program to hopefully a full-fledged court that would handle a much larger docket, because we all know that within our process, our criminal justice process here in Milwaukee, there are many, many cases that we could be handling through this process. The last thing I will say is, as Paige mentioned, I also see my role as if a referral is made and we think that there is something else we can do with this individual along the early intervention continuum, that's what we do. I mean, there are individuals that are appropriate for pre-charge diversion, and we have a prosecutor that specializes in that in the area of mental health. We have an excellent drug treatment court, we have an excellent veterans treatment court, and we have an early intervention deferred prosecution agreement. So one of the benefits of kind of trying to be open-ended about the referrals is sometimes we can steer individuals that tend to be lower risk or have a lower level offense into one of our other programs, which is one of my responsibilities here in the DA's office. So I think that gives you an idea of kind of how the referral process works, what individuals are eligible. We'll talk a little bit more about that. The criteria, again, we look for Milwaukee County residents. We look for individuals of age. So we're talking about all adult system cases. We don't handle juveniles within this particular court. And then, right, we work collaboratively as a team to try to ensure the success of the individual and make sure that they can successfully complete the terms of the the agreement, which sometimes is just termination of supervision by the court and continued probation, or it's whatever the deferred prosecution agreement tells. So again, we've been doing this for almost 10 years. Paige has been involved from day one. I was involved in day one, but at some point we had Assistant District Attorney Kelly Hedge oversee this program on behalf of our office, and she did a fantastic job. So I'm going to let Paige tell you a little bit more about some of the success stories. I would just say from my standpoint, we've been able to take relatively serious offenses and ensure victims that because of the intensity of the mental health treatment court program, we were doing them a service, we were doing the community a service, and ultimately we were able to have people that graduated from mental health treatment court in a much better position to not come back to our system, which is the ultimate goal. We don't want them in the criminal justice system. We want them to know how to properly access resources and manage their lives in a way that does not require them to come into contact with law enforcement. So, Paige, you got a couple success stories that I think you wanted to talk about.
Yeah, just a couple things to add to what Jeff had said. So just keep in mind, if you don't know, that at least right now in the state of Wisconsin, 17 and up is an adult. So if it's a 17-year-old with a mental health issue, we will still look at them. I think everyone here is county-based, so I think you're in the Milwaukee County. That is obviously our kind of gold standard, so to speak. Those are the individuals.
Paige, you muted yourself.
I muted myself. Well, I don't know where I was, but I was just going to say, so 17-year-olds are adults. And then I was going to say that I know most of the people here are in Milwaukee County. That's who you work for. And that's really kind of the main people we're focusing on. Every once in a while, we will have a client who was living here at the time and committed the crime here, but has subsequently moved to a different jurisdiction within the state of Wisconsin. And we have, on a case-by-case basis, looked at them, and we did a very, very strong success case of one of those individuals. So just a little bit about kind of how the program started is that Jeff said he and I have, basically 2006 started a program to try and divert people from the criminal justice system in different ways. Some that have a lot more court intervention, some that have less, with the recognition that you can get people help. We don't need the full force of the criminal justice system for everyone. What we realized pretty quickly in that process, as we were having success, is that too often people with major mental health issues were not getting into the program. Number one, they weren't getting into the program, even if they qualified for, let's say, a diversion, because they weren't competent. We couldn't have a conversation with them. So a lot of times people with major mental health issues were coming in, not because of their criminal activity, but because of their mental health issues. And then the second issue that happened to us is that a lot of the programs we had centered our other programs on had to do with predominantly non-violent cases. And as I'm sure you know, many people who are very ill can somehow, sometimes react in a violent way because they're reacting to a delusion or hearing voices or whatever. And so a lot of times a lot of the people with the mental health issues just didn't fit the criteria of our other programs. So we started a pilot in 2014 with then Chief Judge Kremers, and he actually took over those cases. So he was our judge, and we just tried to, without much of a protocol, without really much of anything, just tried to figure out what would work. And what's interesting is I heard that you're going to have Paul Broadwin come and talk to you maybe next at your next meeting. He was one of the researchers that came, so you can ask him about our program for the pilot phase. And we have had a decent amount of success. I would say in all treatment courts, they're probably somewhere around 50% in terms of, so we're not talking about in some of our other programs with the lower risk people, we might be closer to 70 or 80% success rates. But even the people sometimes who haven't made it successfully through, they never committed a crime again, which is ultimately what we want for our community, even if they didn't make it through the program. So just a couple of stories to tell you about. We had one individual that came in. She was diagnosed with schizophrenia. Her crimes were very serious. She had actually taken, I think it was some type of weapon to her 4-year-old child's neck. Luckily, the police were called by her other children, and it was clear she was hearing voices. She was not coherent. She was not able to really communicate other than mumbling. Luckily, she did not hurt her child. And we put her in the court, and she just did phenomenally well. She happened to have a very strong family. She was blessed with not having alcohol and drug issues, which made it very easy. We needed to get her on the right medication and just kind of educate her and her family a little bit more about what major mental health issues she had and how to make sure she took care of it. She happened to be someone who was legally here in the United States, but wasn't born here. And I think there may have been some issues with how much mental illness was talked about in the community or in her community. And so I think the benefits that she received as she got stronger and stronger, her family got stronger. I think they gained a lot of insight. I think her husband also gained insight and was a very strong advocate for her. And it was a really terrific story. And her cases were amended. And so she ended up only being convicted of 3 disorderly conducts. She's never been back in the system. There was another gentleman who was a recent graduate. He was diagnosed with bipolar disorder, and that one was kind of a little bit of a break for us. We usually have people with schizoaffective disorder and schizophrenia. And he was really interesting because at that point, we did have a doctor who was volunteering his time with us. He thought after interviewing him that he would be a very strong candidate. And he really turned out to be. I think our biggest issue with him was the education around the benefits of medication. When he was well and not on medication, he believed he was always well. And then when things went off the rails, he had limited insight, let's put it that way. I think that in retrospect, he's doing well as far as we know. We probably could have done more around that educational piece in terms of trying to help him understand a little bit more about his symptoms. But he did incredibly well. And one of his frustrations in life with his own mental health issues was that he felt like he never felt like he could move forward in his life. And so one of the groups that volunteers and comes to the mental health treatment court is a group called Project Return. They got him connected to some programming, and he ended up getting his CDL license. And when he graduated, he actually had a good job for $100,000. So it was pretty amazing to see a person who qualified for my services, which are indigent, who probably walked out the door with the ability to make more money than many of us who are sitting in the courtroom as lawyers and others. And again, it just came down to really focusing on what he needed and making sure that he was following through. And then the last person was the out-of-state person. I mean, not out-of-state, out-of-county. And I would say that what I think he had schizophrenia. He had committed a crime here, pretty serious criminal damage to property, was very, very paranoid and quite ill. After he initially lived in Milwaukee, he had parents in another county, and he was up there visiting, and he got very ill and luckily was not prosecuted, but was taken to the hospital. He was given a Chapter 51, and that was, in that community, a real benefit. He stayed in the hospital for close to a month. After being in the hospital for a month, he then went to a 24/7, almost like a nursing home type place where he was watched. As he got better and they were able to see that he would take his medications on his own, he was then moved to a place where a nurse would stop in daily. So within that 6-month period of a 51, he really got this intense level of help. And then he remained in the court. He also successfully completed our court. He went on to, with his schooling, he became a peer support mentor, and he now works in another county as a peer support coordinator. I think one of the questions that I saw was, are there periodic court reviews? And the answer is yes. We meet with clients every 2 weeks for approximately, and Courtney will go through it with you, I think it's the first 60 or 90 days. Then if they're doing well and they meet the other criteria, they'll move to another phase where we're meeting once a month, and then after that it can be even less than once a month. The last thing I'm going to leave you with is just that I know that many times what we hear from case managers is that they're there to be an advocate more so than kind of be the heavy. And what I'm telling you in these courts is we're the heavy. That's what we want to be. And I'm the defense lawyer, and I'm telling you that when a client of mine agrees to go into mental health court and they sign that agreement, they're agreeing to do what the professionals believe are in their best interest. We will listen to someone if there's a certain medication they don't like, but that's only in consultation with their doctor and advocating their concerns. This is not, I come into the court and I'm now going to decide I'm not going to do any of the things that I'm being asked to do. When you're in the court, you have to do it. A client does have a choice. It may not feel like a fun choice, but the choice is I can be a participant in mental health court or my case will be traditionally prosecuted. And that's the choice. So once they make that choice, that's what we're going to hold them accountable to and accountable for. So when you're interacting with your client, know that you will have the backing, but you can remind them that they signed this agreement and these are the terms of it. And if they have questions, they should go back to their defense lawyer. Clients can self-revoke. So if a client just doesn't want to do it in the end, they can self-revoke, but they are at that point, generally, in all cases, have already pled guilty. So then the next step is either sentencing or a jail or prison sentence. So most of the time that doesn't happen. And then lastly, I just want to say that be careful about, and maybe I don't need to say this to you guys, but what we measure as success. There are people who have not made it through our mental health program, but have never committed a crime again and were active participants in the program. They've even come back to visit afterwards. We have had people that were found incompetent in the middle and they never regained competence, but they still benefited from pieces of the program. So while we've had people who have successfully gone from A to Z through the program and have done incredibly well, we've had other people that quite candidly have had ups and downs in the program, but during the 2 years that we had them in the program, they did not commit another crime. Maybe they weren't well when they got out of the program, maybe they've reoffended by now, but in that period of time when they were under the mental health treatment court and being watched every 2 weeks, they did not get in trouble. And so we're not a magic pill. We can't fix everything, and these are lifelong diseases for people. There are other systems like the civil system that frankly needs to get beefed up with services. But just keep in mind, there's a lot of way to measure success. And I would say that people who are willing to at least try, even if ultimately they don't make it through, at least are not committing crimes in the community. And that is a major accomplishment that shouldn't be lost on anyone. So thank you.
Before we move on, I see that there were 2 questions in the chat. One of which is, do we ever go against the victim's wishes with regard to admission into mental health treatment court? And I would say in certain cases, after listening, getting the input from the victim, we do work very hard to, if we believe that treatment is the overriding concern here and mental health treatment is the overriding concern, we will work very hard to convince that victim. And there are victims that are in various states of anger and recovery and response to the trauma. If their position seems to be completely unreasonable and unrealistic with regard to what should happen to the individual, we will, in certain cases, override that. But we work very hard to share with the victim the benefits of an approach like this and why it is so much better in the long run, not only for them as victims, but for the greater community. In other instances, especially in cases where there's traumatic violence and the victim is their concerns or their position is well-founded, we will adhere to that, and we will simply inform the team that we don't believe that this is an appropriate case based on the input of the victim. With regard to the second question about drug offenses, again, this is the great benefit of having now a coordinator.
Now you lose this.
Having a coordinator that will help us identify kind of what the overriding issue is. If it is a substance abuse, that may very well be co-occurring with a mental health. She'll help us make the determination as to which of the programs might be appropriate, but certainly we understand the role that substance abuse plays in situations involving individuals that are have severe and persistent mental health issues. We just want to try to, for mental health treatment court, focus on addressing the mental health. If substance abuse is a component of that, we will certainly incorporate that. But if substance abuse is the overriding concern, that the major criminogenic risk and need, then our drug treatment court is the better place for that individual to participate. So I think those answers, and Paige addressed everything else that was in the chat.
So thank you guys. And with that, we're going to turn it over to Courtney Brooks, the mental health court coordinator.
Good afternoon, everyone. Thank you for having me. My name is Courtney Brooks, and I am the court coordinator for the Mental Health Treatment Court. And my role is basically to be the gatekeeper for this program. So when referrals come in, they come to me and I vet them. So that means I'm looking to see if all the information is there. I'm looking to make sure there's a serious mental illness or severe and persistent mental illness and supporting documentation, and that the underlying offense is not one that would automatically disqualify them for being eligible for this program. Once I've confirmed all those things, I forward the referral on to the attorneys saying, hey, I got this referral. I think it would be a good fit. And then the state follows up with the victims to have conversations. And then once those conversations have occurred and they determine that the victim is in support of this individual entering mental health treatment court as a disposition, an offer is made by the state to the defendant and their attorney. And then I follow up with those individuals to see if they're interested in accepting the offer and moving forward. After that, I get them on the schedule to be admitted to the mental health treatment court. And then once they're admitted, we start the process of moving through the phases. Right now, the program is designed in 3 phases. Phase 1 is stabilization. Anyone can be in stabilization anywhere from 60 to 90 days. It depends on their level of stability upon entering the program and what services are already in place. If they come fairly connected and fairly stable, they will spend less time in phase 1. If they're more on the unstable side and not connected, they will spend more time in stabilization so that they can stabilize and be connected to the necessary services to help them be successful in the program. Once they've completed phase 1, they move to phase 2, which is pro and adaptive habilitation. So we're looking at learning the life skills they need to be successful in general with meeting their basic needs and managing their mental illness and learning how to cope. The length of that stage is determined by the length of time that they will be in the program. That time frame is determined by the state, and then it's broken up to meet the end goal of no longer than 18 months, but a minimum of 12. So the time they spend in phase 2 is dependent upon the length of their time that they've been committed to the mental health treatment court. And then the last stage is long-term stability and continuum of care. By the time a participant meets stage 3, they should be well connected, doing well, and ready to continue to be stable and connected and successful in the community on their own without the support of the treatment court. So that is the end goal, to make sure that we get participants to that part of the program and making sure that the services they were connected to, they continue with after they leave the treatment court. So as I previously stated, the least amount of time someone will spend with us is up to a year, and hopefully no more than 18 months. So the research shows that 18 months is about the time that an individual needs to be in a treatment court to see successful implementation and changes. So not only am I the gatekeeper for the program, but I also manage the schedule for the mental health treatment court, making sure that participants have their next hearing dates and times. if they need resources outside of what their case manager can provide, I come up with those resources. Or in the interim, if they need help until they can be connected, I find those as well. I work closely with all of the team members on the team to compile reports so that biweekly before we go to court, each participant has a detailed report. So every team member knows what's happening with that participant, the areas of concern, and the areas that they're doing well. So that when we go on the record, the judge can give praise and acknowledgement where it's due and encouragement in other areas where the participant tends to struggle. I do keep all the records for the participants. They're kept electronically. I make sure that all of the waivers are signed so that I can communicate on their behalf and the court's behalf so that I have the most up to date information and we are able to service the participants to the best of our abilities. I also serve as the messenger when participants may be struggling or have issues, collateral contacts can reach out to me and share the concern, and then I share them with the rest of the team so that no one person has to worry about being the bad guy. I do that for you. And I just relay the information. I don't reveal the source so that the anonymity is kept, but we're still able to provide that service to the participant and address the issues and concerns that could possibly lead to issues with their success in the treatment court. So once we have all of those taken care of, then it's my job to make sure that I am monitoring the program as a whole, working out the kinks or looking for areas of improvement or people that we need to invite to the table to help us be successful because there may be an area that we didn't think of at the time or as we grow is identified as a new need. So it's also my job to make sure that I'm staying abreast of areas that we can improve in and people that I need to connect with to invite them to sit at the table so that we can properly serve the population. Now, you might ask, what is the capacity for the mental health treatment court? And as Judge Davis explained earlier, there are several treatment courts and one judge. So it's also my responsibility to make sure that we are adequately monitoring the census for the court, which right now is 6. And I will be admitting another individual on Friday. So after Friday, the census will be 7. Right now, based on how the court is designed, we have a capacity of 10. So after this week, there will be 3 slots available, and then we will be at capacity until there's some restructuring and we're able to get additional supports to help with the treatment courts. So I have to make sure that I'm monitoring everyone's phases, the lengths that they're in, and where they're at to make sure that we're not keeping them longer than we should and that they're progressing appropriately and we're not overflooding the court because the goal is to do no harm. And when we do go over the allotted number that we can serve, we do tend to do more harm than good. And that's not what we're about here in the treatment courts. So I'm wear a lot of different hats on any different day. But the biggest part that I play is collecting the information and having conversations for the attorneys and the judge, collecting the information that they necessarily don't have time to do, but I do and I bring it back. So it's a collaborative effort. Right now, of the 6 participants that are in the program, more than half of them have some form of schizophrenia. That is the most common diagnosis that we are seeing at this time, and we make sure that we are advocating for them so that, if we're noticing, that they take oral medications, but they still appear to be symptomatic, we're having conversations about other options as far as treatment goes with that individual for them to have with their provider so that the best decisions can be made so that our participants can still be successful and manage their mental illness while they're at it. Where you all come in as being case managers and service providers, when we partner in the community, I will be reaching out to you to let you know that we have a mutual client that's in the program. And I'm letting you know that this participant is entering the program on this date and time. And I'll periodically be reaching out for updates. I share the signed release of information to make sure that I did due diligence to get the permission on the front end before I reach out to you. If an individual is in custody, I do let you know the week of that they're getting out on the said date at an estimated time. How would you like to go about connecting so that we can make sure there's that continuum of care once they release? So far, our custody releases haven't been going well. I'm just going to be transparent. I do reach out to the case manager to let them know that the participant is getting out. However, there is a delay in the connection and the start of service. And as you know, we have a very, very tight time frame and window to get these individuals connected and keep them connected. So I'm all about trying to strengthen those relationships so that I can right the wrongs that have occurred so far. So I'm just really on board and trying to advocate that please reach back. If I'm reaching to you to let you know that we have a mutual client, they're releasing, please reach back so that we can have an airtight plan so that when they get out, they can start your services and there can be that continuum of care instead of an interruption in care. So if you didn't remember anything else I said, please respond to the emails. Please make sure you reach back so that we can have an airtight plan for the participants in the mental health court so that we can set them up for success on the front end versus failure because somebody dropped the ball. And on that note, I'm going to transition to Erica and Jackie, and they can talk to you more about their roles as case managers supporting the mental health treatment court.
Um, Jackie, I know that we had discussed possibly taking a break at this time. Is this a good time to take maybe a 5 or 10 minute break?
Yeah, yeah, let's do a 5-minute break and then we'll wrap things up when people come back.
Okay, so that means we'll come back at two, what did we say, 5 minutes? Okay, so let's do 2:13. We'll come back at 2:13.
Sounds
And
good.
then when we come back, don't let me forget, I gotta go over certificates of attendance one last time. Thank you, Jackie.
Yeah, yeah.
Okay, we'll see y'all at 2:13. And then Jackie, did you need me to share my screen too? No.
Yeah, no, actually, no. I'll just put it'll be a little bit of a different like background and everything, but I can do it on mine.
Whatever you
It's
need,
the same
okay?
thing.
We'll
Yep.
decide that at 2:13.
Yeah, I'll take care of it on my end.
Okay,
All
sounds
right.
good. I'll see you in a
Thanks.
few.
Okay, bye-bye.
Hi, Pam.
Hi, I agree. Your hair looks adorable today, Amy.
What? My hair does? Who said that?
Somebody said your hair looks adorable. I'm just like, I agree, man.
Thank you. I just washed it. That's all. But thank you.
I wash mine too, and mine gets more curlier when I wash it. Mine
Me
looks
too.
actually better when it's when I didn't wash it. So
Yeah, I think sometimes that's the case too for me. Okay, now listen, I'm gonna run to the restroom. I'll be back at 12 or 2:13.
okie
Bye, you
dokie.
guys.
See you then.
See you in a few. Jackie, did you say you don't need me to share?
Correct. I'll take care of it. It'll just look different than the rest of it.
Whatever you, I am all whatever anybody needs.
Okay. Yeah, I'll just. Courtney was kind enough to put it to reformat what I had into the whole presentation.
Oh, that was
But,
nice.
Yeah. Mine's just a little purple and jazzy. So
Okay,
so,
purple and jazzy it
Yep.
is. Second half is the purple and jazzy half, I guess.
Yes. So
Hi,
just
everybody, if you're coming back from break. Sorry, Jackie, I didn't mean to cut
Oh,
you
no.
off.
I think I was probably just going to remind you to talk about the certificate before I
Oh.
get started.
Thank you very much. Okay, so if you're new today and you're not quite sure how you get your certificate of attendance, the way that it works is the last few moments, I usually plunk it into the comments section, and it is in the form of a link. And that link is, you'll open it up and it will have a survey attached to it. You'll answer all the questions in the survey, push submit, and another link will show up. That link is your certificate of attendance. That is going to be something that you can print, something you can save, something you can send to your supervisor if you need to. So look for the link in the comments section.
You got muted, Amy.
That's weird. I didn't even push a button. What did you hear?
The last we heard was the link in the comments section.
Yep, that's all you need to know.
Perhaps that's all you need. Okay.
Link in the comments section. All right,
All right.
well, we'll continue on with the second half of our program today. Welcome back, everybody, from break.
Right.
I'll have Jackie take over from here. Don't forget to introduce yourself, Jackie.
Okay.
And Erica.
Yep. So it'll be quite a bit less than half the presentation. We just have a little bit of information here to wrap us up, and then we'll likely be getting going a bit early in this icy day, so you all can get on and get out and run any last minute errands you need to run before it gets really bad out. So yes, myself and Erica will be talking. It's going to be kind of building on what Courtney started to talk about with regard to case management's role in the mental health treatment court. And I'm just going to go ahead and share my screen here. I am Jackie Cram. I oversee the community support program in CARS with Milwaukee County. And there we go. Just having a blank about how to make that into a slide. Okay, so as case managers, you have an integral role on the team for the mental health treatment court. And so I just want to talk a little bit about the expectations that there are of a case manager with a client in the mental health treatment court. And so the first thing is when your client enters the court, just provide the team with a summary of what your client's current status is, their goals and services that are currently in place. Just kind of like what's going on with that person, what's been going well, what areas they may struggle in, just kind of so there's no duplication of services, so that the court wouldn't order something that's already going for that person. Provide updates as to the progress towards the goals prior to the hearings. And that's the other piece. In addition to attending the scheduled hearings and assisting your client in attending those hearings prior to the hearings, there's staffings for every client that will have a hearing that day. And it's expected that case manager appear there just to advocate for your client, to let the court know how things are going, needs they may have, just to kind of keep everybody in the loop. You are your client's best advocate, and it's very important that you be there to speak on their behalf and also assist in any way that they may need. And then, of course, assist your client in meeting the requirements of the court, and inform the court of your client's abilities and limitations as it pertains to participating in ordered services. You don't want them to get into a situation where the court's ordering something that you know your client best, you know what their limitations are, That's just another part of advocating for them, to let the court know if they're ordering something that you clearly know wouldn't be attainable for them, so that you can let them know that that's maybe you need to start 3 steps back. That's just one other piece of it. And then with regard for folks that are in the treatment court, we want to make sure that they have all the services needed. So I just put some information on here as to how to refer somebody to the CARS program, just so if they need, they get, because I'd say there may be like one person in the program now that doesn't have case management, but generally folks that are in the mental health treatment court would have that supportive team. So you just go to the CARS website. I put the link there, and then there's a link to the actual referral form that you can fill out right online, and then fax right into CARS or email. And then I will pass it on to Erica to talk a little bit more specifically about the case manager's role.
Hi, everyone. My name is Erica. I actually am a case manager over at Milwaukee Mental Health CSP. I got involved with the treatment court about 2 years ago. I've had a couple of clients that have gone through, some that have been shown great success, some that have had struggles. And I guess I'm here from the case manager perspective. I really got excited when I was able to come into this court with one of our clients. I think it's just a great opportunity, knowing the clientele that we work with and knowing just how much of a struggle it is finding that balance between, the legal system and having a mental health diagnosis or, a substance abuse diagnosis with everything that's going on. And especially when we know that, jail's not going to help them any more than it already is. So in this court, for me on this side, I really just want to encourage anyone who, if you're a case manager and you have a client who enters this court, please be proactive. I mean, like Jackie said, we're here for our clients. We're their advocates. They're not always going to be in a position to say what they can and can't do. They get more freaked out knowing they're sitting in a court, especially if they've had prior legal concerns. So we're there to help. The best part about this court too is there is such an array of people and options, and with Courtney now in it, as a facilitator, she definitely has opened even more doors up that I know I had in the community for clients. Attending staffings are huge. And again, you may not have seen your client for a couple of weeks, still attend a staffing. You still want to be there to state, hey, this is what we've been doing. This is what we are doing. This is what we've tried to do. Again, you're your client's best advocate. And like Jackie said too, there's some that the court thinks that these are great ideas, and in many terms they usually are, but there's a lot of our clients that just aren't to that level yet. And I've watched clients go through the court that they get to that level, but they also have that support. They have the support through the court. Something that I know for myself, I got a little intimidated at the beginning because, again, it is still court. But it took me a little bit to realize that no one's out to get anybody. We're not out to get the client. They're not out to, the whole court is truly looking at the best interest of the client and what's going to be the best opportunity for them to create a better life for them moving forward. So don't feel intimidated talking to a lawyer or the judge or Courtney or anyone else when you know something isn't necessarily right for your client. There's a very mutual respect, which is amazing in this court. And I have to say that everyone I've worked with in the court truly is. It's a learning process for everyone. You're still learning, and let's be real, none of our clients are the same. You have something different every single day. We also get really good at, utilizing each other. with resources and things like that. Again, within the Milwaukee community, you know, there's some programs that people don't even know about. I mean, I've learned of multiples that I've now reused as more open doors. I think that's one of my biggest ones. As a case manager, just I watched other people where the clients were trying very hard, and it was hard when they don't have that support. And I know right now we are all struggling. You know, we are all short-staffed. We are all trying our best because we're here with the hearts. You know, you guys are all here because you truly do care and have passion for what you do and what you do with these clients. And I think this is just, the mental health treatment court is just an extra bonus, and you have so much more support behind you to do the things that you need to do. But you have to be there, you have to be present, and you have to ask the questions. You know, if you don't have the answer, that's okay. You know, hey, I have no idea, but let me go find out. You know, if you know you're not going to be able to make a treatment team meeting, either see if they can push your case to a different week, or I highly encourage having your team know what's going on and have a team member sit in on a meeting. You know, have someone else sit in on a staffing. I know we've had people sit in on staffings before, and court, I'm sorry if I say this and I'm not right, but we've had people sit on them and just shadow. You know, you can do it on Zoom. I mean, it's a bonus when you don't have to go sit in a court for a couple of hours. So I just, as a case manager, I really highly encourage, like, this program is amazing. I don't think I can say anything more about it. As, like I said, I've had two that have not been successful, and I've had one that was. So it's a step in the right direction, and I just highly encourage, like I said, you know, stay proactive. Use, as jokingly it is, use them. Use Courtney. She'll help you. She'll get you to where you need to be. So ask the questions, and don't be afraid to ask the questions, and don't be afraid to stand up for what you know is better for the client. Because like I said, everyone's still learning. Everyone's still growing. So shoot, back to, I don't know who's talking next.
I think we're it. So we can open up for questions for whoever of us presenters are remaining on the call. You can feel free to unmute yourself and ask, or ask right in the chat.
Yep, that's exactly where I was going to go with it, Jackie. Thank you.
I've heard you say it enough times. I know the script.
You really do. Just remember, if you're shy about turning your camera on, it is perfectly okay to put your question in the chat. And I think, like Jackie said too, I'm not sure all the presenters are still on anymore. I think probably some had to slip away.
Well, it seems like there's some questions in the chat that people aren't really addressing.
Will the presentation be shared? That's one I can answer. Yes, and I saw that Judge Davis did send me something too. I haven't had a chance to open up the email yet. And so the good news is, when you enter the change agent meetings, you fill out a registration form. If you put down a valid email address, whatever email address you put in is the email address where things will get sent to you, whatever materials are shared from today.
I know the first one, Amy, you may have gotten, the first one, somebody had asked about documentation from the judge, and she stated that she was going to send you the information. The mental health treatment court just isn't, they haven't been around long enough to have more statistical information on that.
Well, I can look in real time here.
What you got.
Let's take a look.
And then I'm also available to do presentations to team staff. My information is on the PowerPoint. Feel free to reach out and we can set a date, and I will present on mental health treatment court.
It's nice.
Well, I know, Emmanuel, you had one on there too. And I think, I mean, I would revert a lot of it, you know, email Courtney. You know, she'll tell you, yes, they fit. No, they don't fit. She's very quick to answer. she definitely has been a blessing to this court. So I think, you know, if you are questioning it, you know, should I do this? Shouldn't I do this? Are they even qualified? I reach out to Courtney.
And Mary, go ahead.
Yes, and I guess I'll reach out to Courtney. So as far as eligibility goes, can somebody be eligible that has a known significant mental illness and hasn't been treated? And I guess that's the question. They haven't had formal treatment.
So it depends on if we can get them assessed while they're in custody and we can get an actual diagnosis. We have to have a known diagnosis before we can admit anyone. So there's been a few instances where that exact scenario has come about and we've set the individual up to complete a CARS referral. And the CARS referral was able to confirm a diagnosis. So we were able to move forward. Then there's been other instances where their competency was raised and there was a forensic evaluation done and we got our diagnosis that way. So we do due diligence to try to get a diagnosis or get an assessment to see if there is a diagnosis there so that we can help the individual if there is. Does that answer your question?
Yes, it does. Thank you very much.
You're welcome.
Courtney, do you think that you would mind just putting your email in the chat for those who are interested to reach out to you? Otherwise, the other option too is I can send it out when I send out materials.
Yes, I can drop it in the chat for you.
Thank you. You guys see the question too from Bonnie? Where do most of the individuals who appear in MHTC reside? The Health Treatment Court.
So right now, the current participants are all from Milwaukee. They're hailing from the 53209, 53206, or 53218 zip codes.
Any other questions or comments?
So as far as the housing goes, they live with family. Some of them are living in adult family homes, but most of them are living with family. And there's a few that do live in adult family homes or rooming houses.
Hello, this is Paulette Christian. I have a question. So in regards to the referral process, does the participant have to come through the mental health behavioral situation prior, and how much of their physician, or is it a mental health physician that's on the team? What does that assessment look like if that client has not been assessed in that way yet?
So right now, the Mental Health Treatment Court does not have a psychiatrist that is a part of our team. We will be looking to bring the medical college on in July to help us with that piece. So for now, we rely on the community providers. So we do get releases signed where we ask that the attorney who's referring the individual to have the provider send us the records or write something confirming there is a diagnosis for those individuals who have not been assessed to this point, but there is a suspicion that there is mental illness present. We refer for CARS to allow CARS to assess them to try to get a diagnosis that way. The other way that we arrive at a diagnosis is through competency evaluations, where they're evaluated by the Wisconsin Forensic Unit, and then a doctor will provide the findings on a diagnosis that way. Does that answer your question?
Into the, into the stratosphere so we can all make sure we're understanding it properly. But what's the turnaround from referral to actual possibly becoming a participant in the mental health court? I mean, do you have any numbers, or is there a matrix that you're looking at to kind of see what this looks like?
So right now, it depends on how quickly the state is able to make contact with the victims and have a conversation and about whether or not they're amenable to mental health treatment court as a disposition for the individual's case. Um, I started in my role in October and I've admitted several individuals. So it can be as quick as a matter of few weeks to as long as a few months if it's a more complex case. Um, it really depends on when the state is able to have the necessary conversations. I'm able to staff it with my team as a whole for the judge to sign off on the case being admitted. So the quickest turnaround is 2 to 3 weeks, and the longest that I've seen since I've been here is maybe 90 days.
Okay, and I have one more, and then you guys will be done with me. um, you start as young as 17, but for the most part, 17-year-olds should be still under the care of their parents. How does the parents' role play into working with the 17-year-old? And is it the 17-year-olds buy in and the parents, or can they make that decision by themselves? Is it
So
based off of, I'm just a little bit more, I know I'm windy. Is it based off of their type of crime that they committed? Is that a piece of it as well? Or, to what degree? And how does the
so
parents play into a 17-year-old, someone with mental illness?
So legally, 17, they are an adult, so it would be up to them. But the attorneys do reach out to the family for support and background information about their child, because the more background information we have, the more it helps us help their child. And then once they are admitted into the court, I do check in with the family to see how things are going, if there's any issues or concerns, things that they would like for us to address with the individual. But at the age of 17, they are considered an adult, so it is up to that individual, but we do try to include the family to let them know this is how mental health treatment court works. This is what your loved one is looking at in this program. And then once they're admitted, I do communicate just to make sure everything is going well, there's no issues or concerns. And then I share that with the team. Does that answer your
Okay.
question?
Yes, ma'am. Thank you much.
You're welcome. There's a question in the chat about extensive criminal history, later learning about the mental health treatment court. Could it be considered for someone in new or recent charges? And that the answer to that question is yes. I do deep dives on all the individuals that are referred to me. I look at their history. I look at their current offense. I look at their mental health information. I look at the big picture before I make a recommendation on appropriateness. So I take everything into consideration.
Courtney, I think they're asking if you can look at old charges though too, right? And it's only new or recent charges, right? Like for entering court?
Correct. Once something's already adjudicated, we can't do anything with that. It's currently for the new cases, but we can look at the history because sometimes you can see it's prevalent back then and it plays a part. So we can use that to make decisions about current and new offenses.
Good questions, guys. Anybody else? Jackie, Erica, Courtney, I don't know if you're interested to stay on just for a couple minutes in case somebody wants to talk to you personally. But right now we can conclude if you'd like. Just remember that I'm going to drop the certificate of attendance in the chat right now. Remember to answer the questions for the survey so that we know how you felt about the presentation today. And then remember, once you submit that, another link will show up and that will be your certificate of attendance. So thank you everybody for coming. Happy Change Agent Day, and please stay safe on the streets. My gosh, it's going to be just a mess out there, I hear. So good luck, and we'll see you all next month. We're getting closer to see each other again in May. There's
Quick
the
question.
certificate. Yeah.